Across villages, towns, and even the cities in India, reports of caste-based violence continue to emerge. A Dalit groom attacked for asserting a customary wedding rite, a family forced out of its village, a woman assaulted because caste hierarchy was challenged. Each incident is different, but together they raise the same question. If India already has a special law against caste atrocities, why do these crimes continue? Before 1989, crimes against members of scheduled castes and scheduled tribes were usually investigated under ordinary criminal law. Murder was treated as murder, assault as assault. But Parliament recognized that many of these offences were not random crimes. They were committed because of caste, often intended to reinforce social hierarchy, to punish people for asserting equality, or to prevent access to land, education, public resources, or political participation. The Protection of Civil Rights Act of 1955 had already outlawed untouchability. But over time, lawmakers concluded that this alone was insufficient. The law addressed discriminatory practices. It did not properly respond to organized violence, intimidation, social boycott, dispossession, or other caste-based offences that required stronger criminal penalties and dedicated safeguards. That led to the enactment of the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act in 1989. A major catalyst was the Karamchedu massacre of 1985 in Andhra Pradesh, where dominant caste landlords attacked a Dalit colony, killing 6 people and displacing hundreds. The law recognized that caste-based crimes require a different legal response. Not because the victims were different before the law, but because the nature of these crimes demanded stronger protection and greater accountability. The Anti-Atrocities Act introduced a different approach. It identified specific offences committed against members of scheduled castes and scheduled tribes because of their identity. It introduced enhanced punishments for certain caste-based crimes and a set of procedural safeguards that ordinary criminal law did not provide. It envisaged special courts for faster trials. It provided for relief and rehabilitation, and over time, amendments expanded the list of offences and strengthened protections for victims and witnesses. On paper, the framework became increasingly comprehensive. The real question, however, was whether the law worked. To answer that question, the Human Rights Advocacy and Research Foundation undertook an extensive review of the Act's implementation. Drawing on official crime statistics, government records, judicial decisions, and the functioning of institutions created under the Act, the report asked a simple question: has the promise of the law translated into justice on the ground? Its answer was sobering. The legal framework is robust, its implementation is not. Across the country, the report identifies the same failures repeated at every stage of the justice system. Police delay or refuse to register offences under the Act, forcing survivors to fight for recognition before they can even begin to seek justice. The handling of the Hathras case brought these failures into sharp public focus. The Act's provisions are diluted or applied reluctantly, weakening cases from the very beginning. The events surrounding Una exposed how caste atrocities often require sustained public pressure before institutions respond adequately. Poor investigations weaken prosecutions, allowing cases to collapse despite serious allegations. The Delta Meghwal case raised widespread concerns about investigative lapses and accountability. Special courts often exist only on paper, while survivors continue to wait years for trials to conclude. The long legal journey after the Khailanji massacre exposed how justice can be delayed despite national attention. Relief, compensation, and rehabilitation arrive late. Survivors of the Mirchpur violence spent years fighting not only for convictions but also for rehabilitation and compensation guaranteed under the law. Monitoring committees created to oversee implementation and hold officials accountable often meet irregularly or remain ineffective, allowing these failures to continue unchecked. The report argues that these are not isolated administrative lapses, they are systemic failures that recur from the police station to the courtroom and beyond. Additionally, it has also been reported that 97.7% of atrocities against scheduled castes in 2022 were concentrated in just 13 states. It was also reported that only 194 of 498 eligible districts had established special courts, despite the Act requiring such mechanisms. The first test of the law begins when a survivor approaches the police, but the report identifies this stage as one of the most persistent points of failure. It documents delays in registering FIRs, instances where police record offences only under the general criminal law instead of invoking the POA Act. The report also cites RTI data from eastern Uttar Pradesh. Between 2015 and 2019, 568 cases were registered under the POA Act across 17 police stations in Deoria district. Yet, not a single conviction was secured. In neighboring Kushinagar, 754 cases were registered across 13 police stations during the same period, again without a single conviction. In Karnataka, Dalit activists have expressed that police often tried to broker compromises instead of registering offences under the SC/ST Act. In 2025, a Dalit family alleged that after a caste-based assault, the police initially registered the case under general criminal provisions but did not invoke the SC/ST Act. It took sustained pressure before the relevant provisions were added. This matters because once the POA Act is invoked, survivors become entitled to a range of statutory protections, including investigation by a Deputy Superintendent of Police, relief and rehabilitation measures, and other procedural safeguards. The Human Rights Advocacy and Research Foundation's report documents delayed investigations, poor supervision, evidence that was not collected in time, and investigations extending beyond the timelines prescribed under the rules. Additionally, in September 2023, Karnataka Chief Minister Siddaramaiah publicly questioned why convictions under the Act were only 3.44% and why more than 1,100 cases had not even been charge-sheeted within the prescribed period. The report study of Tamil Nadu found that a large number of survivors did not even receive relief within the prescribed timelines, while many received only part of the amount due under the rules. Similarly, it's been reported that over 5,200 compensation claims for atrocity victims remained pending in Bihar, with districts citing lack of funds. When implementation fails repeatedly, who is expected to intervene? The Act answers the question by creating district and state vigilance and monitoring committees. These committees are meant to meet regularly, review investigations, monitor relief and rehabilitation, and ensure that officials comply with the law. The report, however, found that in Tamil Nadu, none of the district vigilance and monitoring committees held all 4 mandatory quarterly meetings required under the rules. The report's chapters on Uttar Pradesh, Uttarakhand, and Haryana describes weak institutional oversight, inadequate implementation of statutory safeguards, and limited accountability for recurring failures. If a survivor manages to overcome every obstacle so far, the case finally reaches court. The POA Act envisages exclusive special courts and special public prosecutors because Parliament recognized that caste-based crimes require focused and time-bound trials. But the review found that these safeguards often exist only on paper. Tamil Nadu offers a striking example. The review found that only 6 of the 32 exclusive special courts required under the law has been established. It also recorded a conviction rate of just 3.6%. Even more significantly, the state did not file appeals against a single acquittal during 2015 and 2016. So, was evidence collected in time? Did witnesses receive protection? Did prosecutors receive the support needed to pursue these cases effectively? The conclusion is plain and simple. India fails to implement legal safeguards against caste-based violence. These findings mirror patterns that continue to emerge in reports of caste atrocities across the country. For Citizens for Justice and Peace, documenting these incidents is only the first step. When reports indicate failures in implementing the SC/ST Act, CJP has repeatedly approached statutory authorities seeking intervention. In Jan 2025, CJP submitted a detailed complaint to the National Commission for Scheduled Castes, drawing attention to a series of reported anti-Dalit atrocities from Telangana, Andhra Pradesh, Chhattisgarh, Karnataka, Madhya Pradesh, Tamil Nadu, and Uttar Pradesh. CJP later submitted another complaint before the Commission, documenting 30 caste-based atrocities across 9 states. These interventions point back to the central question raised by the Human Rights Advocacy and Research Foundation's review. Can a law provide rights to protect the Dalits and Adivasis across the country? Visit cjp.org.in to know more.